Hello everyone, welcome back to SEBI Grade A legal classes. I'm Rajni Yadav, and in today's class we'll be studying tort, and we'll be studying the remaining tort, right? So, okay, let's get started now. So in the last class of tort, we basically studied the introduction, what exactly it is, its derivations, like from where it is derived, definitions, essentials of torts, then what is law of torts, pigeonhole theory. Then we studied two basic principles, two very important maxims of tort, that is injuria sine damnum and damnum sine injuria. Then we studied the difference between civil wrong and the criminal crime, that is the difference between private wrong and the public wrongs. Then we were discussing types of torts, wherein we discussed trespass, then we discussed battery, then assault, then we discussed negligence. Right. Now we have to study after negligence. So the next tort that we'll be studying in today's class is defamation. So defamation is the injury to the reputation, goodwill, and character of a person. A man's reputation is considered as his property, which is more valuable than any other property. So if a person injures the reputation of another, then he does defamation, right? So what is defamation? When somebody injures anybody's reputation or goodwill or character, then it is termed as defamation, because it is also considered as a right to his property, this reputation, his goodwill, his character, all these are considered his right to property, right? So there are two types of defamation. One is libel and the other one is slander. What is libel? It is the representation made in some permanent form, like writing, printing, picture, etc. And slander, second one is slander. It is the publication of a defamatory statement in a transient form, like spoken words or gesture. So basically, it's of two kinds. One is libel and the other one is slander. Libel is in permanent form, which is made through some representation, which is through writing or printing, picture, or any encryption. So this is all in permanent form. So this is called libel. And something which is in transient form, like some spoken words or gestures, something of that sort, that will be called as slander. So what are the essentials of defamation? They are, that is, the statement should be false and hoax. The statement must be defamatory. It must refer to a plaintiff. The statement must be published, right? So what are the essentials? First of all, that statement must be defamatory. It must be false, and it must refer to the plaintiff, and it must be published. So what basically it is saying that it must come to the knowledge of third person. If something is, suppose if I defame you, it is between me and you. If it is between me and you, then how will you be defamed? For something to be defamatory, it is very important that it must come in the knowledge of third person. Third person should know, right? Then only it will be then only it will be called as defamation. Because what is your reputation? Reputation is something which other holds of you, right? It is not something which I hold of myself. I might think I'm a very good person, I'm very well behaved, I have a good character. It does not matter what others hold opinion about me, right? That is very important. That is what is called your reputation. So if other person gets to know something defamatory or something which is false about me, then it will be termed as defamation. So in the case of defamation, there are various defenses that are available to the defendant. One such defense is if the words spoken are true. So if a statement is true, then this will form a complete defense. It should be noted that the burden of proof for showing that a statement is true rests with the defendant. right? The defendant does not have to show that every single characteristic of the statement made is true. Merely that it is substantially true is enough. Second, fair and bona fide comment, right? So that is, if the statement is fair and it is in the interest of the public, it is not a defamation. And third, there is some mistake, right? This is third one, privilege. There are certain occasions when the law recognizes right to freedom of speech outweighs the plaintiff's right to reputation. The law treats those occasions as privilege, right? So what are the defenses available to the defendant against defamation? Are, first of all, if the words spoken are true, then it will not be defamatory. Defendant will not be held liable. If whatever he stated is fair, is true, and bona fide, that is, he stated everything in the best interest of the public, he was fair in that, then also it will not be a defamation. Third, privilege. So, sometimes it happens that you have the right to speak on some occasions. That is why we see in parliamentary debates, in parliaments, whatever is spoken there, it does not fall under the category of defamation because you have absolute liberty to speak whatever you want, right? So the privilege that we are talking here are of two types. One is absolute privilege and one is qualified privilege. Right. So when we talk about absolute privilege, we basically say that no action lies for the defamatory statement, even though the statement is false or made maliciously. It applies to parliamentary privileges, judicial proceedings, and state commission. When we talk about absolute privilege, we basically mean to say that whatever you will say, be it wrong, false, still it will always be exempted. You will never be held liable for those statements. And these kind of privileges generally you get in parliament, and whenever you are in the judicial proceeding and in the state communication, such kind of privileges are provided, right? The other one is qualified privilege. It is necessary that the statement must have been without malice. The defendant has to prove that the statement was made on a privileged occasion fairly. So when we talk about qualified privilege, it is not an absolute privilege. First of all, that means under that you were absolutely free to speak anything that whatever you want to. But herein some conditions are there, as in like you will have to prove whatever I said. It was without malice. And if you can also, the defendant here also can prove that in that particular occasion, he was allowed to speak. That is why he spoke in that occasion. So this is qualified privilege. Now, the next tort that we will be covering or discussing is tort of nuisance. It says nuisance is the unlawful interference with a person's use or enjoyment of land. Acts interfering with comfort, health, safety are the examples of it. Interference can of any way like noise, vibration, smoke, excavation, etc. There are two kinds of nuisance, basically. One is public or common nuisance. The other one is private nuisance or tort of nuisance, right? Public nuisance is a crime, whereas private nuisance is a civil wrong. So, in the law of tort, what we basically study is private nuisance, which is also called as tort of nuisance. Public nuisance is basically a crime, right? This we don't deal here. Public nuisance is interference with the right of public in general and is punishable as an offense. Obstructing a public way by digging a trench or constructing structures on it are examples of public nuisance, right? Now, private nuisance or tort of nuisance. So what are the essential ingredients of this are? To constitute the tort of nuisance, the following essentials are required to be proved. First, there should be some unreasonable interference. And interference is with the use of enjoyment of land, and there was some damage, that is some harm or loss caused to the plaintiff. What are the essentials? Unreasonable interference with the use of land, and some damage was caused to. In the case of Usha Bain versus Bhagya Lakshmi Chitra Mandir, it's a 1978 judgment. And in this case, the plaintiffs, appellants, sued the defendants, respondents for a permanent injunction to restrain them from exhibiting the film Jai Santoshi Ma. It was contended that exhibition of the film was a nuisance because the plaintiffs' religious feelings were hurt as goddess Saraswati, Lakshmi, and Parvati were defined as jealous and were ridiculed. It was also held that hurt to religious feelings was so what was held in this case, this was the contention of the plaintiff. But what court said was that hurt to religious feeling was not an actionable wrong. Moreover, the plaintiffs were free not to see the movie again. The balance of convenience was considered to be in favor of the plaintiff, and as such, there was no nuisance. So herein, they were not liable for the tort of nuisance. So now let's read all the ingredients in detail. So the three elements that we discussed are, will be now dealing in detail. So the first element of nuisance is unreasonable interference. It means interference may cause damage to the plaintiff's property or may cause personal discomfort to the plaintiff in the enjoyment of the property. Every interference is not nuisance. Like if I have a house by the side of the road, I cannot bring an action for the inconvenience which is necessarily incidental to the traffic on the road. So what basically they're trying to say is that not everything will fall under the category of nuisance. There are some conditions which has to be fulfilled, then only it will be a nuisance, right? If my house is on the main highway, how can I expect that? How can I ask all the heavy vehicles not to move from in front from my? How can I ask the heavy vehicles not to go from the front of my house? No, I can't do that. So this will be unreasonable. This will not be held as a nuisance, right? Of course, there will be some traffic and noise of those vehicles in my house. Right. Every interference is not nuisance. Like if I have a house by the side of the road, I cannot bring an action for the inconvenience, which is necessary incidental to the traffic on the road. Right. Next, an unreasonable activity cannot be excused on the ground that reasonable care has been taken to prevent it from becoming a nuisance. Right. If you're doing something unreasonable, you can't come and explain and give a reason that it is not unreasonable. So it cannot be excused on the ground that the reasonable care has been taken. Anything which is unreasonable activity will always remain an unreasonable activity, will always fall under the tort of nuisance. An action or an act which is reasonable does not become unreasonable or actionable due to the sensitiveness of the plaintiff. Like if noise by neighbor does not annoy any ordinary person, but disturbs only the plaintiff due to his oversensitiveness, this is no nuisance. So this is talking about the cases of sensitiveness. Sometimes it happens, there are many persons who are sensitive to few things. So because if something is not bothering to the normal people or the ordinary people, then you being extra sensitive cannot bring a case of nuisance for it, right? Then you will not be granted relief for that. You will not be given damages for that because you are sensitive, extra sensitive, right? So this is not something on the ground of which the damages will be given to you, right? Second is interference with the enjoyment of land, which means interference may cause either injury to property, injury to comfort, or health. When we say injury to property, we mean if there is an unauthorized interference with the use of property of another person through some tangible or intangible object, it is a nuisance, right? Like allowing the branches of a tree to overhang on the land of another person. Next is injury to comfort or health. So if there is an interference, wait. Yeah. Injury to comfort or health. So yeah, if there is an interference with the comfort and convenience in using the premises, then it is actionable under nuisance. However, the law does not take the trifling matters. That is, law does not take the trivial matters or very slight, very small issues into consideration, right? The case law, there's an important case law on this, that is Christie versus Davey. In this case, the defendant filed a case. In this case, defendant filed case and said he was being continuously irritated by the music and singing lessons by the plaintiff. Plaintiff here was a music teacher and was giving music lessons to students 4 days in a week, which totally amounted to 17 hours approximately in a week, right? The neighbors were being aggravated because plaintiffs, the neighbors were being aggravated because of the plaintiff. So what they decided, they also did party where they were beating drums, whistling, shrieking, and this way he was interfering his music teaching classes. So what court held? Court said that giving music tuition cannot be considered as unreasonable use of crowds. That could be restrained by an injunction, but the person who interfered into this teaching by doing party and creating a weird sound have done out of malice, which is a significant factor and has caused nuisance. So what was happening in this case? The defendant, right? The defendant filed the case. In this case, there were two parties. One was a music teacher, and another were normal residents of the colony. So those people filed case against the music teacher, saying that because of his music classes, as he's giving 4 days music classes in a week, it is causing them nuisance. It is disturbing them. So what they decided to teach that music teacher a lesson, though. So what they decided, they also decided to do party in which they were beating trays, whistling, shouting, etc. They were doing. So now when they filed the case for nuisance. So what court said that since giving music classes is a reasonable thing and it cannot be called as a nuisance, but what you guys did was out of malice and you guys actually did or created the nuisance. So they were held liable in this case, right? Now the next tort that we'll study is nervous shock. In English law, a nervous shock is a psychiatric or mental illness or injury inflicted upon a person by intentional or negligent actions or omissions of another. It is a shock which arises from a reasonable fear to immediate personal injury to oneself. Often, it is a psychiatric disorder triggered by witnessing an accident. For example, an injury caused to one's parents or spouse. Although the term nervous shock has been described as inaccurate and misleading, it continues to be applied as a useful abbreviation for a complex concept. The possibility of recovering damages for nervous shock, particularly caused by negligence, is strongly limited in English law. For a case under nervous shock, the plaintiff has to prove the following things. Right, so these are the essential elements for the case to fall under nervous shock. It is necessary chain of causation between nervous shock and the death or injury of one or more parties caused by the defendant's wrongful act. Right, plaintiff is required to prove shock caused to him by seeing or hearing something. Physical injury is not important. His proximity to the accident was sufficiently close to time and place. The three basic ingredients of this tort are that causation that there is a necessary chain, a link between causation of the nervous shock or the death and injury to the plaintiff, and he must also prove that such shock was caused to him by hearing something or by seeing something. It is not necessary to prove some physical injury was there, right? And thirdly, that he must also prove that there was a proximity to the accident with respect to the time and space. Right. So what is the rationale behind this law? The rationale behind the law of nervous shock is that the body is controlled by its nervous system, an essential part of the body, and if by reason of an acute shock to the nervous system, the activities of the body are impaired and as a consequence is prevented from functioning normally, there is clearly a bodily injury. It is important to note that the cause of nervous shock itself is not enough to make it an actionable tort. Some injury or illness must take place as a result of emotional disturbance, fear, or sorrow. So what they're saying that in the cases of nervous shock, physical injury is not important, but there must be some injury or illness which must take place as a result of emotional disturbance, fear, or sorrow. For a plaintiff to receive damages from nervous shock caused by the defendant's negligence, they must prove all elements of the tort of negligence. That is, a duty of care exists, there is a breach of that duty, the causal link between the breach and the shock, right? So in this nervous shock tort, you have to prove there was a link between the breach of that duty and the shock that was suffered to you, that was caused to you, right? And the shock was not too remote a consequence, right? In the cases of nervous shock, we generally talk about primary victims and secondary victims. So let's see who are primary victims and who are secondary victims. A primary victim is a person who is directly involved in an accident and suffers injury as a result of the fault of the tortfeasor. A secondary victim is one who suffers nervous shock without herself being directly exposed to physical danger in the accident to the primary victim, right? So the one who's directly involved in the accident are called primary victim, and who are not directly involved in the accident or they suffer without himself or herself being directly exposed to any physical danger in the accident to the primary victim. So the secondary victims are not those, are those who do not suffer directly out of those accident or any incident of that sort, right? The party who is directly involved in the accident and has a reasonable fear of causing bodily injury is the primary victim. So the ones who are directly involved in the accident and have reasonable fear of causing bodily injury are primary victim. A secondary victim is the one who suffers nervous shock without the primary victim being directly exposed to any physical danger in an accident. So basically, you can say for the primary victim, you can say the one who directly saw that accident, right? And he suffered some shock, nervous shock, then he will be called as a primary victim. Suppose some person meets an accident and someone from that accident scene goes to the house of that deceased person who died in that accident, goes to the house of that person and tells his mother that your son or your anyone, brother, sister, or your relative has died in an accident. Now, this person suffering this nervous shock, he or she will be called as the secondary victim, right? When you were directly present in the accident scene and saw it, primary victim. When somebody came and told you that this and this kind of accident has happened and this person has suffered some injury, right? So now when you're hearing about that accident through somebody else and learning of accident being caused to someone who's related to you, now you're suffering a nervous shock, then it will be secondary victim, right? The case loss in this tort, which is important. This case is important with respect to tort of nervous shock. It is Bordhill versus Young. In this case, Mr. Young had been negligently riding his motorcycle and was responsible for collision with a car in which he himself suffered fatal injuries. Right. At the time of the crash, Mrs. Borhill was in the process of leaving a tram about 50 feet away. Right. So she was at a distance of 50 feet away. Now, Borhill heard the crash, and after Mr. Young's body had been removed from the scene, she approached and witnessed the immediate aftermath. Borhill was 8 months pregnant at the time of the incident and later gave birth to a stillborn child. Borhill subsequently brought an action against Mr. Young's estate, claiming she had suffered nervous shock, stress, and sustained loss due to the negligence of Mr. Young. So what court opined in this case? Court said that Mr. Young was not liable for any psychiatric harm caused to Mrs. Borhill, as she might have suffered as a result of the accident. It was not foreseeable for Mr. Young to see that she would suffer such psychiatric harm as a result of the negligent act of Mr. Young causing a loud traffic accident, nor Mr. Borhill Borhill was sufficiently proximate to the scene of the crash itself. That is, therefore, Mr. O owed no duty towards Mrs. Borhill. So what actually court said in this case was that when the accident happened, right, they were at a very distant places from each other. So Mr. Young could not foresee that if this kind of accident happens, some lady, she would be pregnant, who could come later on after the accident had happened, will see that accident scene and will suffer some, nervous shock. All this could not be foreseeable by any normal man. So how can Mr. Young could foresee such thing, right? So going by that principle, Mr. Young was not held liable and she was not given any damages for this. Other cases, Miss McLaughlin versus O'Brien. In this case, although the plaintiff in this case was not present near the event, she was upset to learn about it. So what happened in this case? The House of Lords held that defendants accountable and broadened the legislation to apply in cases where the plaintiff arrived right after the accident but had not personally witnessed or heard it. Three things, according to the law, will force would need to be determined in each case, right? And it said the group of people whose claims need to be accepted, their proximity to the disaster, and the mechanism that led to the mental disease. So in this case, basically, court gave the principles on which you are to give the damages whenever a case of nervous shock has been brought in before you, right? So in this case also, basically, the plaintiff in this case was not present. So it is also related to the proximity of the plaintiff to the place of accident, right? So the court gave judgment on that basis, on that ground, and gave these three principles. Now the next thought is constitutional thought. The thought of constitutional, basically in the early years, there was a concept that a king can do no wrong. However, with the evolution of democracies, the state started being held responsible for its own action, right? So earlier, the kings were supposed to be someone who can never do any wrong. But with the passage of time, the concept of king was no more. Then the state become a welfare state, Earlier it was a policy state, now it became a welfare state. So everything was in the hands of state, right? And they were now being made responsible for their acts. As a state typically functioning through its agent states were held vicariously liable for the wrongs committed by their agent. So states' liability was evolved through the concept of vicarious liability. And in fact, in Article 30 of the Indian Constitution, which embodies the concept of constitutional tort, it permits the union and the state government to be sued as juristic persons capable of owing and acquiring property, entering into contracts, bringing legal actions, etc. And in the Constitution also, when we read Article 300, then we can see that now, in fact, the states are also held liable. They can sue, they can also be sued at the same time because they have been given the status of juristic persons now. So now, as we all know, the states are also vicariously liable for the acts which are done by them, right? So now it is no more fully exemption on them. Now, in fact, states can also be held liable for the wrongs which are done by them. So now we will be reading important case laws on this topic. The first case that we'll be reading is P&O Navigation Company versus Secretary of State for India. The first case which seriously discussed the question of sovereign immunity. So this is the first time, in this case, the first time discussion happened on sovereign immunity. And in this case, what actually happened in this case, a piece of iron funnel carried by some workmen for conducting repairs of government steamer hit the plaintiff's horse-driven carriage and got injured. The plaintiff sued for damage. The plaintiff filed a suit against Secretary of the State for India in counsel for the negligence of the servant employed by the government of India. So what was held in this case? In this case, it was held the government will be liable for the actions done by its servants while doing non-sovereign function, but it won't be held liable for injuries caused while pursuing sovereign function. So basically, this is the first case on sovereign immunity. And in this case, what was actually held, the court said that, if the state is carrying on any sovereign function, then it will never be held liable for its act. But if the state is carrying non-sovereign function, then you can make even state liable for its act. The second case is related to the state of Rajasthan versus Vijayawati. In the second case, we'll discuss the state of Rajasthan versus Vijayawati. In this case, a government jeep knocked down a pedestrian who died in consequence of the accident. Rejecting the appeal by the state of Rajasthan on the ground of sovereign immunity, the court ruled that the state is liable for the torts or wrongs committed by its officials. In this case, distinction between sovereign and non-sovereign functions were disregarded, but the court observed that the state would not be responsible for the act of the state under Article 300 of the Constitution. Petitioner Vidyavati was awarded a compensation of ₹15,000. The Supreme Court in this case added that in modern times, the state has become a welfare state and socialistic functions. The Supreme Court in this case added that in modern times, the state has welfare, socialistic functions, and the defense of state immunity based on the old feudalistic notion of justice cannot be sustained. So basically, in the earlier case, which is P&O navigation case, court made a distinction between sovereign and non-sovereign. Court made a distinction that is in relation to in what cases punishment will be given to the compensation can be granted to the parties when the state is committing any wrong. So it said if doing any sovereign function, not liable. If doing non-sovereign function, liable. But in this case, what actually happened, court actually opined that, okay, we understand that states are performing sovereign and non-sovereign function, but we also have to go beyond that old notion, old concept of sovereign immunity, right? Because now it is a welfare state, socialistic state, social functions are being performed by the state, and defense of state immunity based on old notions cannot be given, right? if the need of the hour, if in the interest of justice and natural justice demands, then in some cases, you will have to grant damages to the party if the harm is suffered by the plaintiff, right? The second case is Kasturi Lal versus State of UP. In this case, the apex court has adopted a pro-people approach. In this case, the police seized some suspected stolen gold from plaintiff. Later, it was misappropriated by the head constable of the police station, who reportedly fled to Pakistan with the gold. The Supreme Court held that the state is not responsible or is not liable, as impugned act is a sovereign immunity. So, and the court reiterated that state is not liable for sovereign function. This is a bad judgment. You know, this judgment is actually very much criticized, because in this case, what happened, the by stating when by in this case, what happened that police seized some suspected gold. You know, plaintiff's gold were seized by the police, and what happened later on, the constable of the police station stole or misappropriated those gold and fled to Pakistan, right? No charges were made against him because court said that whatever he did was comes under sovereign immunity, and as he was performing a sovereign action, so the state will not be held liable for the act of its servant. So this judgment is very much criticized. The next case is Rudal Shah versus the State of Bihar. In this case, Rudal Shah versus State of Bihar, a public interest litigation case brought before the Supreme Court under Article 32 of the Constitution. The petitioner demanded Rudal Shah's release and compensation for his illegal detention. Rudal Shah was arrested for the murder of his wife in 1953, and in 1968, he was cleared of the charges. Since his acquittal, he had spent 14 years in jail, right? So the court ordered a settlement of rupees 30,000 as compensation for his overdue stay in jail. In this case, the doctrine of compensatory jurisprudence was developed. So the doctrine of compensatory jurisprudence was developed in the case of Rudal Shah versus State of Bihar for infringement of fundamental right. This was the first time the Supreme Court ordered penalties for the fundamental rights violation, right? So in this case, what happened actually, even after being acquitted, Rudal Shah was kept in the jail for 14 years. So for this, he was given compensation by the state. Supreme Court ordered the state to pay compensation to the Rudal Shah for the violation of his fundamental rights. Now, the next tort that we'll study is malicious prosecution. In malicious prosecution, the malicious prosecution is actually the malicious institution against another of an unsuccessful criminal, bankruptcy, or liquidation proceeding without reasonable and probable cause. It is also known as abuse of process, or that is abuse of process of law for personal interest. So basically, what actually you do in the case of malicious prosecution, with malintention, with malice, you file a suit against someone in the court, right? So in an action of malicious prosecution, the plaintiff must prove. So what all things, when the plaintiff is filing the suit for malicious prosecution, what all he has to prove? He has to prove certain things to make his case fall under this category of tort. So he must prove that he was prosecuted by the defendant, that the proceeding complaint was terminated in the favor of the present plaintiff, that the prosecution was instituted against without any just or reasonable cause, that the prosecution was instituted with a malicious intention or malice, that is not with the mere intention of getting the law into effect, but with an intention which was wrongful in fact, that he suffered damage to his reputation or to the safety of person or to his security or his property. So what you have to do, prove that defendant prosecuted you, right? And the prosecution terminated in your favor, and the prosecution was made with malintention or with the malice, and you suffered some loss of reputation because of that prosecution, and it was instituted without any just and reasonable cause. The case which deals with malicious prosecution is Kamta Prasad versus National Buildings Constructions Corporation Private Limited. In this case, the officer of the respondent corporation found certain articles missing while preparing inventory and checking up with the stock register. The plaintiff was prosecuted under section 403 of the IPC, but was given the benefit of doubt and hence acquitted. Right. Now, the plaintiff brought an action for malicious prosecution. The plaintiff could not prove that he had been harassed by the officers. There was held to be reasonable and probable cause for prosecution of the plaintiff, and the fact that the plaintiff was not harassed indicated that there was no malice, and hence the charge was not held. So in this case, basically what happened, there was an officer who was charged and prosecuted under section 403 of IPC. But due to some lack of evidences, or due to basically not lack of accident, but due to benefit of doubt, he was acquitted of the charges. Now what he did, he goes to the court and files the case for malicious prosecution. Now what court observed, court said that all the time while he was in the custody or in the prison, the officers did not harass him, right? And in fact, they had reasonable cause and reasons to arrest that person. So it proves that there was no malice on their part. Considering all these facts, his case of malicious prosecution was rejected, and the charge was not held. Right. Now we have studied so many torts. So if somebody files a case against you for one or the other tort, and the defendant, can a defendant claim any defense against it? So in torts, we will also find the defenses which are given against those law of torts to the defendants, right? So whenever a case is brought against the defendant for the commission of a tort, and all the essential elements of that wrong are present, the defendant would be held liable for the same. Even in such cases, the defendant can avoid his liability by taking the plea of defenses under the defenses available under the law of torts. So basically what they are saying is, if you can prove these defenses which are there, then the defendant can avoid his liability. So when a plaintiff brings an action against the defendant for a tort committed by him, he will be held liable for it if there exist all essential ingredients which are required for that wrong. But there are some defenses available to him using which he can absolve himself from the liability arising out of the wrong committed. These are known as general defenses in the law of tort. The defenses available are given as follows. So the defenses, all the defenses which are available to him are voluntary non-fit injuria, or the defense of consent. The wrongdoer is the plaintiff. Next is inevitable accident. Next is act of God. Next is private defense. Next is mistake. Then necessity. Then statutory authority. So let's study each one of them one by one. The first one is voluntary non-fit injuria, or the defense of consent. In a case, if a plaintiff voluntarily suffers some harm, he has no remedy for that under the law of tort, and he is not allowed to complain about the same. The reason behind this defense is that no one can enforce a right that he has voluntarily abandoned or waived. Consent to suffer harm can be expressed or implied. Some examples of the defense are when you yourself call somebody to your house, you cannot sue your guest for trespass, right? If you have agreed to surgical operation, then you cannot sue the surgeon for it, that he cut my body like this and that, right? If you agree to the publication of something you were aware of, then you cannot sue him for defamation, right? A player in the games is deemed to be ready to suffer any harm in the course of the game, right? Suppose in the game of football, both the teams know that they will get injured in the game. They might get hit by the ball. injuries, right? Similarly, a spectator in the game of cricket will not be allowed to claim compensation for any damages suffered. Yeah, so exactly. If you go to watch any game like bat ball, so of course, and when you will read the tickets, no, in fact, you'll find there are clauses properly written on it that if you suffer any loss, it is at your own risk. So right. So when you go to watch these matches, then also you will not be given any relief if you suffer any loss or if the ball hits you. You cannot claim for damages, right? Because you yourself came to watch this match. You yourself agreed for the loss which might happen to you in consequence of watching those matches, right? For the defense to be available, the act should not go beyond the limit of what has been consented. Yeah, but you must also see, so this defense will only apply to what has been agreed by the plaintiff. If something beyond that agreement happens, or if something beyond that consented part happens, then the defendant will be held liable, right? Suppose if the cricket match is happening and your house is nearby you and the ball is, just imagine, not, it will never happen, but if it happens, the ball hits your window glass and it breaks your glass and it hits you. In this case, you can claim for damage, compensation, because here you did not agree or you did not consent to suffer this loss by watching this match, right? There's a case which is Hall versus Brooklands Auto Racing Club. In this case, the plaintiff was a spectator of the car racing event, and the track on which the race was going on belonged to the defendant. During the race, two cars collided, and out of which one was thrown among the people who were watching the race. The plaintiff was injured. The court held that the plaintiff knowingly undertook the risk of watching the race. It is a type of injury which could be foreseen by anyone watching the event. So the defendants were not held liable in this case, right? Because you yourself agreed or consented to this harm when you agreed to watch this match, right? Next case is Padmavati versus Dukka Naika. In this case, the driver of the jeep took the jeep to fill petrol in it. Two strangers took a lift in the jeep. The jeep got toppled due to some problem in the right wheel. The two strangers who took lift were thrown out of the jeep, and they suffered some injuries, leading to the death of one person. The conclusion which came out of this case are, the master of the driver could not be made liable as it was the case of a sheer accident, and the strangers had voluntarily got into the vehicle. And the principle of non-voluntary fit injuria and the principle of voluntary non-fit injuria was held applicable, right? Now, in the case of Woolridge versus Summer, a plaintiff was taking some pictures standing at the boundary of the arena, right? The defendant, whose horse galloped at the plaintiff, due to which he got frightened and fell into the horse's horse and was seriously injured. The defendants were not held liable in this case since they had taken due care and precautions. Now, the next defense which is available to the defendant is inevitable accident, right? Accident means an unexpected injury, and if the same accident could not have been stopped or avoided in spite of taking all due care and precautions on the part of the defendant, then we call it an inevitable accident, right? It serves as a good defense as the defendant could show that the injury could not be stopped even after taking all the precautions and there was no intent to harm the plaintiff. The case law in this defense are Stanley versus Powell. So in this case, the defendant and the plaintiff went to a pheasant shooting. The defendant fired at a pheasant, but the bullet, after getting reflected by an oak tree, hit the plaintiff and he suffered serious injuries. The incident was considered an inevitable accident and the defendant was not liable in this case, right? The next case is Assam State Corporation versus etc. Federation Limited versus Srimati Anubha Sinha. The premises which belong to the plaintiff were let out to the defendant. The tenant, that is the defendant, requested the landlord to repair the electric wirings of the portion which were defective. But the landlord did not take it seriously and failed to do so. Due to a short circuit, the accident fire spread in the house. No negligence was there from the tenant's side. In an action by the landlord to claim compensation for the same, it was held that this was the case of an inevitable accident and the tenant is not liable. Now the next one is act of God. In this defense, act of God serves as a good defense under the law of torts. It is also recognized as a valid defense in the rule of strict liability, as was held in the case of Ryland versus Fetcher. This we'll be covering in the later part of this discussion. Right. The defense of act of God and inevitable accident might look same, but they are different. Act of God is a kind of inevitable accident in which the natural forces play their role and causes damage, for example, heavy rainfall. Right. Essential required for this defense act, natural forces working should be there. There must be an extraordinary occurrence and not the one which could be anticipated and guarded against reasonable. So when we talk about, see, they generally this act of God and inevitable accident look same, but they are not, right? In inevitable accident, it is some accident which they're talking about, some, interference of human mind or human body or something is there. But these are something which is beyond our control, right? In this act of God, you find things are done which are beyond your control, like vis major, right? There's a word terminology which is vis major. Here something natural forces has something got to do with it. It is something which is related to things like earthquakes, tides, storms, heavy rainfall, storms, etc. If some damage has happened because of such natural forces, then it will be called as act of God. So what is working of natural forces? In Ramalinga Nadar versus Narayan Reddy, the unruly mob robbed all the goods transported in the defendant's lorry. It could not be considered to be an act of God, and the defendant, as a common carrier, will be compensated for all the loss suffered by him. So yeah, here you will see that human intervention is there. So this you cannot relate or called as equivalent to act of God, because in act of God, there is some major natural forces are there. There is a role of natural forces. It is just human intervention. So this is not act of God, right? This case is important in act of God. Generally, they are asked. Nicholas versus Marshland is related to act of God. The defendant created an artificial lake on his land by collecting water from natural streams. Once there was an extraordinary rainfall, heaviest in human memory. The embankments of the lake got destroyed and washed away all the 4 bridges belonging to the plaintiff. The court held that defendants were not liable as the same was due to the act of God. In this case, the defense of act of God was given because the loss happened because of the heavy rainfall which happened, which is not under the control of any human. It is this nature, which is something which is, it is not human intervention. It is through natural forces. That is why they were not held liable. Now the next defense is private defense. The law has given permission to protect one's life and property, and for that, it has allowed the use of reasonable force to protect himself and his property. So, of course, we all know that we have the right to save our body, life, property, right? So, for that, if any danger is you think you might face with respect to your body or property, of course, you can use private defense so as to save your property or your body, right? So the use of force is justified only for the purpose of self-defense. So you must see if you're using the force of self-defense, the use of, it must be, so if you're using this private defense, it must it will be justified if it is only for the purpose of self-defense, right? If it is for your self-defense, then only this use of force is justified, right? And there should be an imminent threat to a person's life or property. So if there is threat to person's life or property, and imminent threat, right? Imminent threat of life and personal liberty, then only you can use this force of self-defense. For example, A would not be justified in using force against B just because he believes that someday he will be attacked by B. Is there any imminent danger that you see here? Right? Had he been standing with a gun pointing at him, then of course he can use private defense. But he's just apprehending that in some future, which he don't know when, he might attack me. In that case, you cannot use private defense. You cannot attack him and say, I used it in a private defense. The force used must be reasonable and to repel an imminent danger. For example, if A tried to commit a robbery in the house of B, and B just draw his sword and chopped his hand, then this act of A would not be justified, and the defense of private defense cannot be pleaded. So what they're trying to say is that the private defense should be in proportion to what the defendant has acted, right? If somebody is just showing you his hand, you can't cut his hand. You cannot shoot him for that act and say that I used it in private defense. Use the force in proportional to what he did, right? So there should be a proportionality between the act of the private defense and what defendant did. Now next, the protection of property. For the protection of property also, the law has only allowed taking such measures which are necessary to prevent the danger. So similar thing applies when you are preventing your property also. So the force should be proportional. So for example, fixing of a broken glass pieces on a wall, keeping a fierce dog, etc. is all justified in the hours of law, right? This is justified, right? But you can't do that if in case you just want to protect those glass pieces of your wall. You can't put electrocuting wires, right? No, you can't put. You can keep a dog there and with the sign of beware of dog, but you can't put an electrocuting wire so as to protect that piece of glass. It will be, these two acts will not be proportional then. Important case law in this is Ward versus Holbrook. In this case, the defendant fixed up spring guns in his garden without displaying any notice regarding the same, and the plaintiff, who was a trespasser, suffered injuries due to its automatic discharge. The court held that this act of the defendant is not justified, and the plaintiff is entitled to get compensation for the injuries suffered by him. Right? Because both acts were not proportional. That is why he was held liable. Similarly, in the case of Ramanuja Mujali versus M. Gangan, in this case, a landowner, that is the defendant, had laid a network of live wires on his land. The plaintiff, in order to reach his own land, tried to cross his land at 10 p.m. He received a shot and sustained some injuries due to the live wire, and there was no notice regarding it. The defendant were held liable in this case, and the use of live wires were not justified in the case. See, in this case, why this person was held liable? Because just to protect or just to stop some people from entering your land, you put live wires on that without even any notification, without any notice about it. At least when you're putting such things like live wires or something like that, you are supposed to put a caution notice with respect to it. So therefore, since he did not place any notice with regard to any caution of live wire, therefore he was held liable. Now, next defense is mistake. There are two types of mistakes. One is mistake of law, the other one is mistake of fact. When a defendant acts under a mistaken belief in some situation, then he may use the defense of mistake to avoid his liability under the law of torts. In Morrison versus Ritchie and Company, the defendant by mistake published a statement that the plaintiff had given birth to two twins in good faith. The reality of the matter was that the plaintiff got married just 2 months before. The defendant was held liable for the offense of defamation, and the element of good faith is immaterial in such cases. Next case, in Consolidated Company versus Curtis, an auctioneer auctioned some goods of his customer, believing that the goods belonged to him, but then the true owner filed a suit against the auctioneer for the tort of conversion. The court held auctioneer liable and mentioned that the mistake of fact is not a defense that can be placed here or pleaded here, right? Now, the next defense is rule of necessity. If an act is done to prevent greater harm, even though the act was done intentionally, is not actionable and serves as a good defense, right? So it should be distinguished with private defense and an inevitable accident. The following points should be considered when taking the defense of necessity. They are: in necessity, the infliction of harm is upon an innocent, whereas in case of private defense, the plaintiff is himself a wrongdoer, right? In necessity, the harm is done intentionally, whereas in case of an inevitable accident, the harm is caused in spite of making all the efforts to avoid it, right? So, for example, performing an operation of an unconscious patient just to save his life is justified. So, basically, in necessity, what they are saying is that in order to prevent a larger harm, you can cause some small harms, right? And this small harm can even be caused to an innocent person, right? Suppose if there are so many huts placed, if there's, I mean to say, if there are so many huts there is a locality which is in which there are so many huts, they are one after the other, and one hut has caught the fire, and the fire is spreading towards all the huts. So, of course, in order to prevent the circulation of this fire, of course, you can break a hut which is in between, right? So, of course, you will break that hut so that this fire will stop and the further transfer of fire will not be there, right? Similarly, in the similar way, if you can say, suppose there is a lion and he's holding a small child in his mouth, right? And you all know that he is, coming towards a group of people. Of course, then in order to protect the so many group of person, you can shoot at lion. And in that case, it might happen that you might injure or you might hit the baby in his mouth. So in this case, you can take the rule of necessity. That is, it was in the need of the hour that such an act of mine was required to do. Therefore, I did cause harm to the innocent one so as to prevent the larger harm, right? Important case law in this are Lake versus Gladstone. In this case, it was held that the forcible feeding of a person who was hunger striking in a prison served as a good defense for the tort of battery. Next, Pope versus Sharp. The defendant entered the plaintiff's premises to stop the spread of fire in the adjoining land where the defendant's master had the shooting rights. Since the defendant's act was to prevent the greater harm, so he was held not liable for trespass. This is what I was actually telling. So in order to prevent greater harm, you can cause the small harm, right? Carter versus Thomas. In this case, the defendant who entered the plaintiff's land premises in good faith to extinguish the fire at which the fire extinguisher workmen were already working was held guilty of the offense of trespass. So why he was held guilty in this case? Because in this case, the firemen were already there who were, extinguishing the fire. So why did you enter? What if some harm happens to you now? So this will be called as a case of trespass. He was held liable for trespass. This was not the case of necessity, right? Kirk versus Gregory. In this case, A's sister-in-law hid some jewelry under the after the death of A from the room where he was lying dead, thinking that to be more safe place. The jewelry got stolen from there, and a case was filed against A's sister-in-law for trespass to the jewelry. She was held liable for trespass as the step she took was unreasonable. Right? Now, the last defense that we'll study now is statutory defense, statutory authority, the defense of statutory authority. So if an act is authorized by the act or statute, then it is not actionable even if it would constitute a tort otherwise. It is a complete defense and the injured party has no remedy except for claiming compensation as may have been provided by the statute. Immunity under statutory authority is not given only for the harm which is obvious, but also for the harm which is incidental. In the case of Vaughan versus Staff Vault Rail Company, sparks of an engine of the respondent's railway company were authorized to run the railway, set fire to the appellant's wood on the adjoining land. It was held that since they did not do anything which was prohibited by the statute and took due care and precaution, so they were not held liable. Now, in the case of Hammersmith Rail Company versus Brand, the value of the property of the plaintiff depreciated due to the loud noise and vibrations produced from the running trains on the railway line, which was constructed under a statutory provision. The court held that nothing can be claimed for damage suffered as it was done as per the statutory provision, and if something is authorized by any statute or legislation, then it serves as a complete defense. So the defendant was not liable in this case. Now, in the next case, which is Smith versus London and South Western Railway Company, the servants of a railway company negligently left the trimmings of hedges near the railway line. The sparks from the engine set fire to those hedges, and due to high winds, it got spread to the plaintiff's cottage, which was not very far from the line. Right? The court held that the railway authority was negligent in leaving the grass hedges near the railway line, and the plaintiff was entitled to claim compensation for the loss suffered. Now we'll be talking about the strict and the absolute liability concept, and this is the last thing that we'll be discussing in this subject, that is law of torts. So yeah, strict liability. The principle of strict liability evolved in the case of Ryland versus Fetching. So you should know strict liability relates to Ryland versus Fletcher. In the year 1868, the principle of strict liability states that any person who keeps hazardous substances on his premises will be held responsible if such substance escapes the premises and causes any damage. Right? So, going by the principle laid in this case, it can be said that if a person brings on his land and keeps some dangerous things, and such thing is likely to cause some damage if it escapes, then such person will be answerable for the damage caused. The person from whose property such substance escaped will be held accountable even when he hasn't been negligent in keeping the substance in his premises. The liability is imposed on him not because there is any negligence on his part, but the substance kept on his premises is hazardous and dangerous. Based on this judicial pronouncement, the concept of strict liability came into being. There are some essential conditions which should be followed or fulfilled to categorize a liability to be held as a strict liability. So what are the essentials of strict liability? They are, there was a dangerous thing and it escaped. There was a dangerous thing and there was a non-natural use of that dangerous thing and it escaped, right? So, the dangerous subject means the defendant will be held if there is a dangerous substance. The defendant will be held strictly liable only if the dangerous substance escapes from his premises. For the purpose of imposing strict liability, a dangerous substance can be defined as any substance which will cause some mischief or harm if it escapes. Things like explosives, toxic gases, electricity, etc. can be termed as dangerous things. And the second thing that we have to see is there was a non-natural use of that dangerous thing. So, to constitute a strict liability, there should be some non-natural use of the land. In the case of Ryland Fletcher, what actually happened? The water was collected in the reservoir, was considered to be a non-natural use of land. So storage of water for domestic use is considered to be natural, but storing of water for the purposes of energizing a mill was considered to be a non-natural use by the court. So when the term non-natural is to be considered, it should be kept in mind that there must be some special use which increases the dangers to other, right? And the third essential is that dangerous thing escape, right? One more essential condition to make the defendant strictly liable is that the material should escape from the premises and shouldn't be within the reach of the defendant after its escape. So actually, in strict liability, you are allowed to claim some exceptions, right? Strict liability has some exceptions attached to it. They are plaintiff's fault, act of God, act of third party, consent of the plaintiff, right? So what is a strict liability? A strict liability arises in those cases wherein you bring something which is very hazardous in your place and you make non-natural use of that thing and it escapes from your place, right? So then you will held strictly liable. But in the case of strict liability, you are allowed to claim some exceptions, right? This principle of strict liability has some exceptions attached to it. The first exception is plaintiff's fault. If the plaintiff is at fault and any damage is caused, the defendant wouldn't be held liable as the plaintiff himself came in contact with a dangerous thing. Important case law on this is Ponting versus Roe. Right? So that is to say, in the case of strict liability, you can claim some defenses. The first defense is of plaintiff's fault, right? Second is of act of God. So if something was beyond your control or beyond any human agency's conduct, then also you can get a defense under strict liability. Third defense is act of third party. The rule also doesn't apply when the damage is caused due to the act of a third party. The third party means the person is neither the servant of the defendant nor the defendant has any contract with them or control over their work. Fourth defense which is available in strict liability is consent of the plaintiff. That is to say, this exception follows the principle of volatile non-footed Julia. For instance, if an A and B are neighbors and they share the same water source, which is situated on the land of A, and if the water escapes and causes damage to B, you can't claim damages as A wouldn't be liable for the damage because they both consented for the use of that water. No, that is why. Now, the next concept and the last concept that we have to study is absolute liability, which says the rule of absolute liability in simple word is it can be defined as the rule of strict liability minus the exceptions, right? So if you remove the exception, it will become a case of strict liability. That is to say, in the case of strict liability, you are allowed to claim some defenses. But if a thing or if an act is made absolutely liable, then you are not provided any exception or you will not claim any defense for that, right? In India, the rule of absolute liability evolved in the case of MC Mehta versus Union of India. This is one of the most important judgment which relates to the concept of absolute liability. So you must know, for strict liability, the case law is Ryland versus Fletcher, and for absolute liability, the important case law is MC Mehta versus Union of India. In this case, the facts of this case are that some oleum gas leaked in a particular area in Delhi from industry. Due to the leakage, many people were affected. The apex court then evolved the rule of absolute liability on the rule of strict liability and stated that the defendant would be liable for the damage caused without considering the exceptions to the strict liability. Right. So, according to the rule of absolute liability, if any person is engaged in an inherently dangerous or hazardous activity, and if any harm is caused to any person due to that accident, which occurred during carrying out such inherently dangerous and hazardous activity, then the person who is carrying out such activity will be held absolutely liable. The exception to the strict liability rule will also not be considered, right? So the rule laid down in the case of MC Mehta versus Union of India was also upheld in by the Supreme Court in the case of Bhopal gas tragedy, right? So just a revision and a difference between the strict and the absolute liability, right? See, everything is same in absolute liability and strict liability. But in strict liability, you are allowed to claim some defenses. But in absolute liability, no defense is allowed. If you did an act of that sort, then you will be absolutely held liable without any exceptions, right? So this is it for this class. I hope you really liked it. Thank you so much.